It is April 2026,
Wow.
and a woman named Jessica Mann is walking up the steps of a Manhattan courthouse.
Right.
And before we dive into the legal mechanics or the neurobiology we're covering today, I really want to center exactly who Jessica is for you.
Yeah, that is so important.
She is an aspiring actress. She's a hairstylist. She is a full human being who has spent over a decade carrying the profound weight of an assault that happened back in 2013.
Which is just, I mean, a staggering amount of time.
Exactly. And as she crosses the threshold of that courtroom, she's preparing to face a jury and her abuser for the third time for the exact same allegation.
The sheer endurance required to simply walk into that room is, well, it's staggering. We're talking about a level of psychological stamina that, most people will never be forced to summon in their entire lives.
Which really brings us to the whole mission of our deep dive today.
Yeah.
We are pulling from a massive stack of sources for this one. We've got legal journals, neurobiological research, contemporary news reports.
It's a lot of material to get through.
It is. But the goal is to explore the grueling aftermath that survivors face within the criminal justice system. And I want to set a very clear framework for you right up front.
Right, the focus of the discussion.
Yes, we are not spending our time analyzing the psychology of the perpetrator. We are not exploring, what makes an abuser tick or diving into their childhood.
No, the perpetrator is really simply the catalyst for the systemic failure we're analyzing today. They are not the protagonist of the story.
Not at all. Instead, we are looking at why the legal system forces survivors like Jessica to just continually relive their trauma. We're going to unpack how the hard science of human memory fundamentally clashes with these rigid courtroom expectations.
Yeah, and we'll also explore what a truly trauma-informed justice system could look like. Because, the current system is operating on a fundamentally outdated understanding of human biology.
Right.
We are essentially running modern trauma through a 19th century legal filter, and the friction that creates is just devastating for survivors.
So let's break down the specific legal labyrinth that Jessica Mann has been forced to navigate. Because her timeline, it really perfectly illustrates how the system isolates survivors.
It really does.
So we go back to 2020. The original trial in New York, the perpetrator is convicted and sentenced to 23 years. But then, fast forward to 2024, and the New York Court of Appeals overturns that conviction.
Yeah, and the overturning of that conviction hinges on a very specific legal mechanism regarding witness testimony.
Right, the Molyneux rule.
Exactly. In New York, the courts have strict rules about what they call Molyneux witnesses. Basically, these are witnesses brought in to testify about prior, uncharged acts.
Acts that aren't specifically on trial at that moment.
Right. So in the 2020 trial, the judge allowed several women whose allegations weren't tied to the specific criminal charges to take the stand. The prosecution's goal was to demonstrate a pattern.
To show the jury exactly how he operated.
Right. To prove that the defendant's actions were systematic and that there was absolutely no ambiguous mistake regarding consent.
The logic there makes sense to me. If someone operates with the exact same playbook across multiple victims, doesn't the jury need to see that playbook to understand the crime?
You would think so. But the New York Court of Appeals ruled in 2024 that allowing those Molyneux witnesses was just too prejudicial against the defendant.
Too prejudicial.
Yeah. Their argument rests on the idea that, the jury might convict the defendant simply because they believe he's a bad person with a history of bad behavior, rather than focusing solely on the evidence of the specific crimes charged. They essentially argued it put his character on trial.
Wow. And so that ruling forces a grueling retrial in 2025.
It does.
And in that second trial, the jury convicts the perpetrator of an assault against another immensely brave survivor, Miriam Haley.
Yes.
But then they acquit him on charges involving a model named Kaja Sokola. And for Jessica Mann, the jury deadlocks.
They couldn't reach a verdict.
Right, they can't reach a verdict, leaving her in this awful legal limbo and triggering this third trial in April 2026, which focuses solely on her allegations.
Which really brings us to a fascinating and honestly deeply frustrating discrepancy in American law.
Because of California.
Exactly. While New York was overturning the 2020 conviction over the inclusion of those additional witnesses, this exact same perpetrator was convicted in California in 2022 and sentenced to 16 years.
Because California operates under a totally different legal philosophy, right?
Completely different. Their law gives judges much greater discretion to allow propensity evidence in sexual assault cases.
Meaning witnesses in California actually can testify about prior bad acts to prove motive, opportunity, or intent. They actively want the jury to see the pattern.
Yes. It's a fundamental difference in how the two states weigh the scales of justice. New York prioritizes the risk of prejudicing a jury against the defendant. California, on the other hand, places a higher value on providing the jury with the full context of a perpetrator's behavioral pattern.
Which is so crucial in sexual assault cases where, physical evidence is often scarce and cases come down to credibility. I look at the legal logic of the New York system, and I have to say, it feels like it is inherently designed to ignore the reality of serial abuse.
It really does.
If a court overturns a conviction because hearing from multiple victims is deemed too prejudicial, the system is essentially demanding that a single survivor bear the entire burden of proof in a vacuum.
Right. It strips away all the context.
Exactly. It forces women like Jessica, Miriam, and Kaja, who, by the way, took the incredibly taxing step of agreeing to be named publicly, to stand completely alone.
And legal scholars and victim advocates echo that exact critique. By severing the context, the court creates this artificial isolation for the survivor. I mean, providing consistent, agonizing testimony across multiple trials spanning nearly a decade it's a marathon of endurance.
So the courts demand that these women provide a flawless, unchanging narrative under intense scrutiny over a span of 10 years.
Yes.
But if you actually look at the neurobiology of what happens to a human brain during an assault, demanding a perfect linear narrative isn't just difficult, it is biologically impossible.
It is. The friction between legal procedure and biological reality is severe here, because we have this pervasive, incredibly damaging societal concept of the ideal victim.
Oh, the ideal victim myth.
Right. Society, and by extension the jury, carries this implicit expectation that a person facing absolute terror will respond with calm, strategic action.
Like they're an action hero or something.
Exactly. They expect a victim to physically fight back, to scream, to immediately flee the scene, and then to march into a police precinct with a perfectly organized chronological timeline.
But our source material on the neurobiology of trauma completely dismantles that expectation. Let's look at the brain's defense circuitry. Because when a human being is subjected to an extreme threat, the brain's executive functioning essentially just shuts down.
Right. The key player here is the amygdala.
The smoke detector.
Yes, it functions as your body's smoke detector. Its entire job is to constantly scan the environment for danger. And when it detects a catastrophic threat, it doesn't wait for your conscious thinking brain to analyze the situation and weigh the pros and cons.
There's no time for that.
No time at all. The amygdala bypasses conscious thought and instantly activates the HPA axis, the hypothalamic pituitary adrenal axis.
And the mechanism there is that the HPA axis floods the body with massive amounts of stress hormones, right? Specifically adrenaline and cortisol.
Huge amounts, yes.
I always picture the brain's prefrontal cortex, the part responsible for logic, planning, and executive function, like the pilot of an airplane.
That's a great way to look at it.
Yeah, and when that cortisol floods the system, it's like the pilot suddenly gets locked out of the cockpit during severe turbulence.
Exactly.
The autopilot takes over entirely, executing these hardwired maneuvers just to keep the plane in the air. Yet, months or years later, the courtroom expects the survivor to explain the exact navigational, logical choices they made while locked out of the room.
That analogy perfectly captures the biological hijacking that occurs. The autopilot only knows raw survival. People are very familiar with the concept of fight or flight, but for victims of sexual assault, especially when the perpetrator is someone they know or when escape is physically impossible, fighting or fleeing are rarely viable defaults.
Because if you can't run and you can't win a physical fight, the brain has to find another way to survive the turbulence.
Exactly. So it initiates extreme, involuntary survival reflexes, like dissociation.
Dissociation. Break that down for us.
It's profound. The brain literally splits the traumatic experience away from consciousness. The survivor might feel completely detached from their own body, almost as if they're floating near the ceiling, watching the event happen to someone else.
Wow.
Yeah, it is a neurological anesthetic, basically a way to survive an unsurvivable moment.
And then there is tonic immobility, which is so often weaponized by defense attorneys.
Unfairly weaponized, yes. Tonic immobility is a temporary involuntary paralysis. The muscles go entirely rigid.
Like they literally cannot move.
Literally. The person might feel a drastic drop in body temperature. They cannot speak, they cannot move their arms or legs, but they are fully, agonizingly aware of everything happening to them.
That sounds terrifying.
It is. And there's also collapsed immobility, where the heart rate and blood pressure drop so drastically that the person loses muscle tone entirely, sometimes to the point of just fainting.
And the crucial distinction you have to hold on to here is that these physiological responses are completely beyond conscious control.
100%.
And survivor doesn't decide to freeze, just like your pupils don't decide how to dilate in the dark. Yet, you put a survivor on the stand, and a defense attorney will point to that biological freeze response and say, well, she didn't fight back, she didn't scream, therefore she must have consented.
It is a catastrophic misrepresentation of science. It penalizes victims for the very physiological mechanisms that kept them alive.
Right.
And that biological hijacking doesn't just dictate physical behavior in the moment. It permanently alters how the memory of the event is recorded.
Which brings us to the hippocampus. If the prefrontal cortex is the pilot, the hippocampus is the brain's archivist. It organizes explicit chronological memories. It builds the timeline, filing away events by saying, first this happened, then this, then this.
Under normal circumstances, yes. But during a trauma, the amygdala is sounding the alarm so loudly and the brain is flooded with such a toxic level of cortisol that the hippocampus is essentially short-circuited.
It just goes offline.
Completely offline. It physically cannot integrate a continuous timeline.
So if the archivist is offline, how is the brain storing the event at all?
The amygdala takes over the recording process, but it doesn't record a linear movie. It records fragmented sensory details, basically whatever it deems essential for immediate threat assessment.
Okay, so just bits and pieces.
Right. Researchers refer to these as flashbulb memories that coexist with these profound fragmented memory gaps.
So a survivor might have an undeniably vivid, crystal clear memory of the rough texture of a blanket, or the specific smell of a cologne, or the sound of a zipper.
Yes, exactly.
But because the hippocampus was short-circuited, they might be completely unable to tell you the layout of the room, or how long the assault lasted, or what sequence the events occurred in.
The peripheral details are dropped entirely because they just aren't necessary for immediate survival. But the legal system views those fragmented memory gaps as evidence of deception.
Which is so infuriating. The sources include a deeply powerful quote from Chanel Miller, the survivor who was assaulted at Stanford University, and whose victim impact statement just totally changed the conversation around sexual assault.
Her words are incredible.
They really are. She described the experience of cross-examination in a way that truly haunts me. She realized the defense attorney wasn't looking for the truth. He was looking for chronological inconsistencies to exploit.
Right.
She said he littered my night with intentions and poor decisions, suggesting they had everything to do with the final act.
Wow.
Yeah. He dissected trivial peripheral details to smother the emotional reality of the assault.
Her observation really highlights how traditional cross-examination is practically designed to dismantle a traumatized witness. It demands a flawless linear chronology, a chronology that the traumatized brain physically could not encode.
If you look at the science, doesn't traditional cross-examination feel like an exercise in just gaslighting a survivor's biology?
It really does. It functions as a form of secondary trauma. The adversarial legal system operates on the premise that truth is found through linear consistency.
But that's not how trauma works.
No, in trauma, truth is found in the sensory fragments. When a lawyer aggressively demands a timeline and drills into why a victim can't remember the color of the curtains or the exact time they left a room, they are actively demanding something the victim's brain cannot provide.
And then, crucially, they label the victim a liar when they fail to produce it.
Exactly.
It's infuriating to realize the architecture of the courtroom is fundamentally at odds with the architecture of the human mind. But we are also looking at how to rebuild this system.
Thankfully, yes.
There are actionable, structural solutions emerging globally that aim to create trauma-informed justice. And that evolution has to start at the very first point of contact, which is the police interrogation.
Standard police interrogations are disastrous for traumatized brains.
How so?
Well, typically an officer will ask rapid-fire, close-ended questions. They constantly interrupt to force the narrative into a chronological timeline.
Right.
For a victim whose hippocampus was offline, being forced to invent a timeline causes extreme distress and honestly leads to inaccurate testimony.
Because you are asking the pilot to navigate when they are still locked out of the cockpit.
Exactly.
So what is the alternative?
A new model is gaining traction called FETI, the forensic experiential trauma interview. It completely abandons the demand for a chronological timeline.
Oh, interesting.
Yeah, instead, the interviewer asks open-ended sensory questions like, what are you able to remember with your five senses? Or what is the most difficult part for you to forget?
I see the biological mechanism there. By asking about a smell or a sound, the interviewer is legally bypassing the short-circuited hippocampus and pulling raw data directly from the amygdala.
Precisely. It allows the survivor to access those flashbulb memories without the pressure of inventing a sequence. You gather far more accurate, visceral evidence when you meet the brain where it is, rather than forcing it to perform a task it isn't capable of.
But what about inside the courtroom itself? Because facing the person who abused you, literally breathing the same air as them, has to trigger that amygdala smoke detector all over again.
It absolutely does, which is why some courts are trying to implement structural changes to the physical space. In the U.S., there's a legal precedent, Maryland v. Craig, which allowed a vulnerable witness to testify via closed-circuit TV.
To protect them from the defendant.
Right. The goal was to protect the witness from the paralyzing terror of directly facing their abuser.
But doing that creates massive tension with the rights of the defendant, right? Because the Sixth Amendment Confrontation Clause guarantees a defendant the right to confront the witnesses against them.
It is a profound legal friction. Balancing victim safety against constitutional rights is incredibly delicate, and the tension peaks when you introduce Faretta rights.
Faretta rights.
Yeah, that's the constitutional right of a defendant to represent themselves in court.
Which opens the door to the ultimate nightmare scenario. A perpetrator acting as their own lawyer, standing up in a courtroom and personally cross-examining the person they assaulted.
It is institutionalized re-victimization.
I can't even imagine.
Courts attempt to navigate this by appointing standby counsel, meaning they require a court-appointed lawyer to ask the actual questions, even if the defendant is steering the legal strategy.
Yeah.
But the proximity and the adversarial nature, they remain deeply traumatizing.
You know, we don't force victims of car crashes to perform their own surgeries. We recognize they need medical infrastructure. So why do we expect victims of profound psychological trauma to navigate a highly adversarial legal system without specialized emotional and structural armor?
That is a question the United Kingdom is answering much more proactively than the United States.
Oh, really?
Yeah. The UK model acknowledges the biological reality of trauma and adjusts the legal environment accordingly.
Walk us through what the UK is doing differently to mitigate that trauma.
Well, in the UK, victims of sexual offenses are automatically designated as intimidated witnesses.
Okay.
That official designation qualifies them for a suite of special measures. For one, they're provided with an independent sexual violence advisor, or ISVA.
What role does an ISVA play in the courtroom?
They are professional court supporters who provide continuous advocacy. They can sit with the survivor while they testify, providing this physical, emotional grounding presence in the room.
That must make a huge difference.
It really does. The UK also widely utilizes live links, allowing these witnesses to give their evidence via video feeds from entirely different rooms so they never have to breathe the same air as the defendant.
Wow.
And crucially, if a defendant in the UK chooses to represent themselves, the law strictly prohibits them from personally cross-examining the survivor.
So they are actively building armor into the system. The UK is looking at the victim and saying, your biology is reacting normally to an abnormal event, and we will adjust the architecture of the courtroom to fit your biology.
Exactly.
They prioritize getting the most accurate evidence possible over stressing the witness to the breaking point.
It is a philosophy of mitigation rather than destruction.
Think about what this means for you as you process this massive gap between science and the law. Right now, the American criminal justice system is largely operating in the dark ages of neurobiology.
Very much so.
By demanding perfect timelines and expecting fight-or-flight responses, it forces survivors to endure what many advocates call a second assault on the witness stand.
It asks them to perform an impossible biological task and then, punishes them when they fail.
But the core of this deep dive isn't just a critique of a broken system. The true center of this story is the legacy of the women who are forcing this unyielding system to evolve.
Yes.
Jessica Mann, Chanel Miller, Miriam Haley, Kaja Sokola, and the countless other survivors whose names we may never know.
Their legacy is absolutely not the prison sentence that may or may not be handed down to the perpetrator.
No. Their legacy is their sheer, undeniable courage. by walking up those courthouse steps in Manhattan over and over again, they are refusing to be silenced by a system designed to isolate them.
Right.
They are forcing society, judges, and juries to finally look at the raw reality of trauma. They were the architects of a long overdue systemic reckoning.
They are dragging the legal system, honestly kicking and screaming, into the modern scientific era.
And so, I want to leave you with a final thought to mull over. If our justice system is truly designed to uncover objective truth, will it ever be fully just? Until the architecture of the courtroom is entirely redesigned from the ground up to reflect the actual science of the human mind.
It's a question we can no longer afford to ignore.
We really can't. Thanks for taking this deep dive with us.